What's up, everybody? Pumped to be here with you. Um, it has been a crazy day. I'm still at this conference. It's winding down. Tomorrow morning is the last session. I went and did something cool for YouTube today, making a connection that, I'll tell you about later. It's been kind of a while in the works, having to do with golf, and a YouTuber that does some golf stuff on here. Was able to connect with him over in Orlando today. And had the conference stuff, had a couple work meetings and calls to do in between. And then we had our elections. There was the awards dinner, and every year the Young Lawyer section presents an award. So I got to present the award at the lunch today, which was cool. And then the Young Lawyers actual meeting that they do at the annual convention, which is where the baton was passed to me last year. This year, I passed the baton off. And what's cool is instead of a baton, you pass a gavel. And when you start, they give you the gavel, which I have at my house. And when you finish, they give you the base, which is cool. So I got this base just now that just finished at 5:15, and I ran over here and changed. And also today, which was cool, my first time on News Nation, talking about a case we haven't discussed on this channel at all. That Casey White case, the escaped convict, stuff going on with that. If you want to check out News Nation, I don't know if it posts on YouTube, if it's live on TV. I have no idea. They asked me to pop on for that, so I did that too. So an incredibly busy day, but I am pumped to be here with you to talk about Brian Kohberger, to talk about cameras in the courtroom, to talk about us, the public, and also the people that are consuming, but also taking part in this public discussion on social media, on YouTube, Facebook, wherever you're watching this, wherever you do consume content, especially if you're not getting it from mainstream media, who also takes part in this as well. But I think it's a combination of mainstream media and media adjacent types like our channel here in our community here. I posted about Tucker Carlson, speaking of that, on Twitter. And of course, with any little hint of politics, some people get very angry about that. I'm not planning on talking about anything Tucker Carlson talks about, any of his opinions, just purely the model that he's doing potentially of going from being on mainstream media under contract with Fox to now on Twitter, posting potentially right now, just like as a person, his First Amendment right to talk. And if they're going to try to say he's breaching his contract, that may be something interesting if you all want to talk about it. Thank you, Nancy, if you watched on News Nation. And then right after, Christina says, no, they're the worst. They're a news station. Listen, nowhere I go, this is what I can promise you. Nowhere I go, I don't care if it's another YouTuber. I don't care if it's, Megyn Kelly. I don't care if it's News Nation. I don't care what it is. Nowhere I go am I going to change the way that I think and believe and look at these cases. I am still going to speak the same way, have the same opinions, break it down the same way that you are used to. And if they don't like it or they don't want it, then obviously they won't have me back on, which is fine. But I think that part of the conversation is they want open discussion, and they want somebody that actually practices in these areas and handles these kinds of cases to talk about it. I won't go on talking politics. I am not an expert in politics. I'm not even that into politics. But if it's about the law, if it's about cases, if it's about how lawyers act, how trial lawyers act, especially, and things like that, I'll go on I don't want to say pretty much anywhere, but if that's the conversation they're having and they're willing to have an open and balanced conversation, I'm in. Is all I'll say. And hopefully you guys keep coming around. But if you don't, I think you should reconsider and think about having conversations that are open with everybody, as we do in our chat. And I like to have everybody in, everybody's different opinion. So hit the like button, subscribe, all that stuff. But let's get into Brian Kohberger. Let's get into cameras. Let's get into what we can do. We can literally have an effect on this. And actually, we are, because they are watching. I promise you they are watching. I didn't believe it. You all told me they were. And you all are correct. They are watching. Johnny Depp's lawyer, one of his lawyers, reached out to me after that case. Months and months after, actually. Number two, Mark Eingart, I'm going to mess up his name. The defense lawyer for Scott Peterson reached out to me and appreciated. Again, if you remember, I wasn't exactly incredibly nice to his client the first video. And that's a good segue. Directly after this video, turn on whatever you need to turn on to redirect. It's going to go right into the Peterson opening statements and the first day and a half of witnesses. That recap is going to be right after this because I have a dinner reservation at 6. So I've got to be off the live at 6, but we're going to redirect you to that. If you want to see an opening argument, not an opening statement, but an opening argument that gets cut off by the judge after multiple sustained objections because it was argument, make sure you stick around for that. But he reached out to me and just said, I think it's cool you look at this case balanced. I hope you have an open mind, and I do have a mountain of evidence. I respect that. And I think he's a good trial lawyer. I can already tell. And then this case, and this specifically, the references that they make in their filings, this Brian Kohberger case, they are watching. I promise you they're watching. And we're going to look at two documents. The first is the objection to the media's motion to get rid of the gag order or amend the gag order. And we're just going to look at section D because it's the only kind of different discussion that we haven't already had, rather than the other one talking about, balancing different rights and things like that. So the amended non-dissemination order is necessary in this case to protect the party's right to a fair trial. The first part of the amended non-dissemination order prohibits essentially any speech concerning the case and is sometimes termed a no comment order. Here, the issue is with an order whose entry indeed must be reasonable to avoid substantial likelihood of material prejudice. The question then is whether the court properly entered the order and applied the governing law. Again, this is the defendant, Brian Kohberger, objecting to the media's motion. The media insists that the record does not show that the magistrate conducted a hearing before issuing the order. This court is aware that the magistrate had a duty pursuant to Idaho Code of Judicial Conduct Rule 2.15 to take appropriate action where attorneys engage in conduct in violation of the rules of professional conduct. Moreover, it has a duty to safeguard Mr. Kohberger's right to a fair trial. Thus, if the magistrate was aware of conduct concerning the behavior of attorneys in this matter, it had a duty to implement an order to correct behavior. This court now has the opportunity to make a factual record. The media, in its most recent filings, argue the parties have had their chance to do so and claim to permit them to do so now would be an ambush. This argument is difficult to take seriously, especially given the fact that Mr. Kohberger made it known he would provide a record on May 11th, 2023, when he objected to the media's attempting to have a quick set hearing. And also, so the media doesn't want them to be able to present experts and things like that. And also, given the fact that Mr. Kohberger requested at the hearing on May 22nd for the non-dissemination order to be considered on the date that this court offered the week of June 25th, so as to give everyone more time, a request the media rejected. In any case, it is this court's discretion whether to take additional evidence for a reconsideration. I would expect the court would. Why not? If you can get additional evidence, you can get additional information, it's always helpful, and the media has the opportunity to do the same thing. So as long as it's fair and not prejudicial to one side, I would expect the court to agree with this. This court can start by noting that there have been somewhere around 46,000 media stories on this case so far. Okay, so here are some numbers. 46,000 media stories. There have been 2.1 billion individual exposures to this story. This court can conclude that public interest is intense. That doesn't always mean it's bad, though, right? Just because there is public interest, even if that public interest is intense, it does not mean it's bad. It does not mean it's prejudicial. Then this court can consider the pervasive nature of the reporting. Here is where we, as the public and people that consume and discuss this stuff, can come into play, as we've spoken about in this case already. Since November 13th, 2022, on the day of the tragedy, media have never stopped reporting on this case. The lowest point appears to be a week in February when only somewhere around 2,000 stories were made public. And he's right. Every day something's happening in this case, and every day the media is reporting on it. And it seems like, I've even said it all the time. I feel like I'm talking about this case because every time something like this is filed, people have questions. And if people have questions, I think it's important to answer those questions if I can. I can't answer all the questions. And I haven't done videos on some things, but if I can, I think it's important to talk about this stuff and for you all, the public, to learn why the public can't get certain information. The court should want that. The court should want fair and balanced explanations of this stuff. That's exactly what the court should want. So we should be allowed to talk about this stuff, but we've got to do it the right way. Then this court can consider the nature of the publicity. The media coverage of this case has been uniformly abysmal. I take issue with that, okay? If you are going to use words like uniformly abysmal, that means everywhere, right? A monolith of everybody talking about this case is talking about it abysmally. I disagree with him. Are certain people, are certain media, mainstream media stations? Sure. But everybody is not. And I don't think that's fair. And once you start to do that, as you know, you start to lose credibility with me. But I give a lot of grace, and so we'll kind of see how it goes. And we'll see if he, kind of corrects and just says for the most part, things like that. The media coverage of this case uniformly abysmal, even ignoring the true crime community on social media. So he's ignoring that. Why, you might ask? But even ignoring that, because there are some that I think are being fair and there are some that I think are being unfair and already convicting him in the court of public opinion. Professional media such as NBC Dateline, News Nation, aforementioned, and Fox News have been a never-ending circus of bad facts and worse opinions, all intended to see Mr. Kohberger John, see if you can throw a poll up there. Do you agree with him? And we're going to say not uniformly, but the majority of media reporting on this case, including News Nation, Dateline NBC, and Fox News, has it been abysmal? Yes or no? So majority of mainstream media reporting on this case, has it been abysmal? Because I think a lot of it has. A lot of it has, but I don't think it's been uniformly, and I want to know what you guys think. To be sure, none of these organizations knows Mr. Kohberger, fair. And some will occasionally remind viewers that he has not been convicted yet. More than occasionally here, but I don't think he's talking to us. If I'm being honest, I don't think he's talking to us. I don't think he watches us. I don't think he knows what we talk about on this channel specifically, but he's focusing more on that Dateline NBC episode, which I took issue with as well, if you remember. Did some reels on it, did some shorts on it, some reactions on it. And some of what News Nation, same thing. I'll go on there, happy to contribute, happy to help them out if they want. And they help me out, obviously, with exposure and things like that. But I like talking about this stuff. But that doesn't mean I'm going to pull punches if I disagree with something that they've done or a report that they've done. And I think they know that, and I think they're cool with that, which is why I respect people that are cool disagreeing. But I think that's where he's focusing. And there's an occasional mention that he's not been convicted yet, but none put on any substantive information about the case, preferring instead to tantalize viewers with gory theories and whatever nightmares their parade of quote-unquote experts can create. Even after this court admonished the media at the previous hearings, in this case, to recall it has a duty to truth and upholding the Sixth Amendment, only a handful thought it worth reporting. Okay, so let's pause there for a second. I agree with him. If I'm in the media, I am even more cautious after the judge's comments. But the media would respond and say, you're saying we have bad facts. You're saying we're taking one thing and running with it. That's because we don't have any of the real facts. We've got to search. It's like prohibition. You may get some dangerous alcohol as opposed to getting the safe stuff. And you may be getting it from less than perfect sources. So I think that, he's kind of arguing out of both sides. Like they're reporting on bad facts, but we don't want to give them any of the real facts, Judge. So I think that's a bad argument. I do think over sensationalizing and convicting him before his trial and before they know all the facts and acting like they know everything and know Brian Kohberger personally, that he's an incel or whatever and a serial killer and he must have done this before and he must be convicted of the case in Pennsylvania. I've condemned them for that as well. And I think the judge should as well. And I think that is why we can't have nice things sometimes. I don't want this stuff to continue. The poll isn't tabulating. They're saying, John, it's not registering the vote. Can you work on it again? Maybe pull it down and try again. We're working on the poll. But I think that we really need to think about how we do this. And I think all the media and all the YouTubers and social media people talking about this case need to make sure they're doing it the right way. Finally, this court can consider the behavior of the attorneys and their agents. For whatever reason, Mr. Gray has apparently decided the non-dissemination order does not apply to him. Attorneys for the other victims and witness have all remained silent. The parties have been largely silent, though if it can be believed, NBC Dateline claims to have a leak. The parties have been comparing the coverage of the experts giving their latest fantasies to the public to Mr. Gray expressing his client's support for the death penalty. Mr. Gray had more than twice the exposure to the public as the most widely heard expert. So what I will say is, I think there's an argument that the discussion of the death penalty may not be violating the non-dissemination order. I think Mr. Gray has been trying. The poll is abysmal. That's not working. So just pull the poll, John. Forget it. There's a glitch, I guess, on YouTube. Just pull the poll down. But anyways, I think Shannon Gray has been trying to abide by the non-dissemination order, and that's why he wants more clarification. I don't think this is a fair criticism of him. As for prejudice, the most obvious is the effect on impaneling a jury, which we've already kind of read through or talked about before. Mr. Kohberger also offers the declaration of Dr. El Alali, explaining how the media's constant barrage of negative news subtly alters a jury pool. I don't disagree there. And this is probably the expert they have discussing the media coverage. Dr. L also provides research showing that the speech of attorneys and parties to a case have a much larger impact on a case compared to others. So what I don't like about that finding is that means every case should just not be public, and attorneys and people should not be able to talk about the case. That is wrong. You get nothing from me. You do not pass go. You do not collect $200 if you're going to give a blanket statement that lawyers and people talking about cases is generally bad. That they have a much larger impact, and therefore they should not be able to talk. Oh, people don't understand the meaning of abysmal. Abysmal is bad, horrible, tragic, terrible. That's my bad. Yes, Claudia, I agree with you there. But yeah, so again, you cannot tell me that you're just going to take all that away and we can't talk about any case. And now it's going to be behind closed doors and it's no longer public access. No, thank you. Not in America. Maybe in another country. However, there are other groups affected by constant negative publicity. The media's insistence on seeing Kohberger convicted and killed can have effects on others who are part of this case. Witnesses seeing the insanity may not want to testify. Fair. But witnesses, here's another thing, okay? Because we're talking about these cases as if they're abstract. And that's why you want to talk to a lawyer that has these kinds of cases and deals with witness testimony, criminal cases, sometimes high profile, sometimes not. Sometimes incredibly heinous crimes, sometimes, theft or something like that, or cheating on your taxes. People don't think it's as horrible, obviously, as the crimes alleged in this case. Almost every case, civil, criminal, whatever, witnesses don't want to come. It's inconvenient. They're scared of the defendant. They're scared of prosecution. They're scared of law enforcement. They're scared to be adverse to law enforcement. They're scared of the courtroom. So this does not just happen in high-profile cases. So that's important, I think, to point out. Really important. Witnesses might not want to testify. Those afraid of testifying are far more likely to have information that will exonerate Mr. Kohberger, as they will have to deal with those who in the media have helped convince them that no amount of evidence matters in this case. And I agree with him that that's wrong, but I don't agree with him that snuffing it out or telling the media they can or telling the media less or having no cameras, I don't think that's going to fix that problem. Even this court, faced with angry public pressure created by the media and those feeding it, may feel the pull of to go with this crowd, saying the judge may even be affected. The single question in our minds is whether a petition alleging that the trial took place in the midst of a mob savagely and manifestly intent on a single result is shown on its face unwarranted by the specifications which may be presumed to set forth the strongest indications of the fact at the petitioner's command. This is not a matter for polite presumptions. We must look facts in the face. Any judge who has sat with juries knows that, in spite of the forms, they are extremely likely to be impregnated by the environing atmosphere. And when we find the judgment of the expert on the spot, of the judge whose business it is to preserve not only form, but also substance, to have been that if one juryman yielded to a reasonable doubt that he himself later expressed in court As a result of most anxious deliberation, neither prisoner nor counsel would be safe from the rage of the crowd. We think the presumption overwhelming that the jury responded to the passions of the mob. Of course, we are speaking only of the case made by the petition and whether it ought to be heard. Upon allegations of this gravity, in our opinion, it ought to be heard. Whatever the decision of the state court may have been, and it did not need to set forth contradictory evidence or matter of rebuttal, or to explain why the motions for a new trial and to set aside the verdict were overruled by the state court. There is no reason to fear an impairment of the authority of the state to punish the guilty. We do not think it impracticable in any part of this country to have trials free from outside control. But to maintain this immunity, it may be necessary that the supremacy of the law and the federal constitution should be vindicated in a case like this. It may be that on a hearing, a different complexion would be given to the judge's alleged request and expression of fear. But supposing the alleged facts to be true, we are of the opinion that if they were before the Supreme Court, it sanctioned a situation upon which the courts of the United States should act. And if, for any reason, they were not before the Supreme Court, it is our duty to act upon them now and to declare lynch law as little valid when practiced by a regularly drawn jury as when administered by one elected by a mob intent on death. Assuming, as we necessarily do, that this court would never do such a thing, the intense public sentiment in this case will necessarily color perception of every decision this court makes, eventually leading to some who will claim the court favors one side or the other. So the appearance of impropriety. None of this is good for our justice system. All of this is an absolute disaster for Mr. Kohberger. Keeping the amended disseminated order means the media will have to report facts as they come out and are vetted by the court. Keeping the order means certain involved parties and lawyers are committed to trying this case in a courtroom, not in the press. Keeping this case in the courtroom sends a signal to the public that our courts and participants in our justice system believe in the system, not in outrageously biased media, which can resolve our toughest issues. Looking then at the broad and vague order, this court can quickly do away with any possible infirmities by making it plain. Attorneys, their agents, law enforcement, and anyone else with business in this case, including the victim's family, need to let the justice system work. However much it may help the horrific pain of the victims' families to scream at the system, their alternative mob justice is far worse. It helps nothing to come to court assuming guilt. It helps nothing to overcome law in Latah County and kill an innocent man or have a worthless conviction overturned. Mr. Gray and the Gonsalves family have made it clear they want justice, but there is no history of harassing local law enforcement to provide justice now and violently ever turning out well. In this case, the record makes it clear that the magistrate court was responding as it is to required to do for purposes of due process and the judicial canons to the media coverage of this case. Even the magistrate court went too far. Even if they went too far, that is something that is best addressed by this court reverting to its original non-dissemination order. However, when considering what is appropriate, it should be noted that no one affected by the amended administrative order except the attorney whose behavior brought it about and has defied it is trying to get this court to let them talk to the media. There's literally no benefit to our judicial system so long as it is ethical and cares to find truth to changing the status quo. And then the conclusion. So shots absolutely fired at Shannon Gray, no doubt about it. And listen, while I think he's right about the media assuming guilt, convicting too early, acting like they know Brian Kohberger's character and his past and that he's done this before, I do think the public has a role. And I do think it's important for the public to know what's going on and to be able to talk about it. But if that's how we want to talk about it as the public, if that's how the news and the media want to report on it, this is what we're going to get. The mob mentality and everybody agreeing and wanting, to publicly convict this guy and make it over and not give him a fair shot, be all in the name of justice, I disagree with. I don't think that's appropriate. And I think we need to stop doing that. And if we stop doing that, then we will be able to talk about it more freely and have open discussion about it. I'm going to hit some questions now. MJ with Carrie Lynn. Conspiracy theorists will keep us from watching. I think that is a possibility. Dana. We love you because you are so fair and make points for both sides. Saw you on Megyn Kelly, and I was hoping you could say more because she was going off the rails with that stuff. May not even be true. You are much needed in this media. And Dana, I think that's the point is whatever you want to think about Megyn Kelly, at least she has me on and lets me speak my piece. She may disagree with it. And again, her taking it too far may be part of the problem. Or her talking about one side and having people on to talk about another side, maybe that's more appropriate. And I think we need to learn how to have balanced discussions. And I think news stations and people that only give one side and only talk about one side could potentially be part of the problem. And I think it's totally perfectly fine for you and anybody else that may disagree with Megyn Kelly or whoever it may be. And I think Megyn Kelly expects it. She understands people are going to disagree with her. And I know people are going to disagree with me at times. And the open discussion is the important part, and being fair and balanced in how we look at this stuff is the important part. Tom, Peter, passing the gavel, always momentous. Yes, it is. My B-day is tomorrow and gifting myself time off now to be with the Lawyer You Know family. Great community. Happy birthday, Tom. Thank you so much for being a part of this community. It's awesome. We love having you. Jojo, some reporting I've seen is abysmal. I think there are too many holes in this case for a decision. Now, I'd love to see all the evidence if allowed. That's why we want cameras at the trial and microphones at the trial. Not right now. We do not need to try the case now. That's an important thing that I don't know if we've discussed. We don't need to know all the answers right now. We don't need to convict him or exonerate him right now as we discuss this case. We can talk about what's happening, why these legal procedures are happening, why they're asking for this, or why they have to file a motion to compel, why this deposition may be taking place. We do not need to know all the answers right now. That's what the trial is for, and that's what the jury is for. Leanne, okay, but they've had a gag order the whole time, so aren't the adverse reports unaffected by the gag historically? This is part of the issue. Do you think Vallow set a precedent for no cameras? Crime Spies, we are about to find out when we read through their motion to not allow cameras. Chrissy, welcome. And Elizabeth, welcome to the new members here. Leanne, Peter, if they are talking about how bad the news is for BK and there's been a gag order the whole time, how has it helped so far? So this was your other question again, and I agree with you. Would it make it better if the media knew what was going on? Maybe yes, maybe no. But if the gag order is not even helping that, again, I feel like it's kind of arguing out of both sides of your mouth, right? That's what it feels like a little bit. Nicole Wheeler, regarding Peterson, does receiving admonishments during opening statements affect an attorney's ability to convincingly present his case? And does it undermine his rapport with the judge or jury? Nicole, I want to answer you so bad, but I answer this question in the video that I do that's going to play right after this. So I hope you can stick around to get that answer. If you can't stick around, shoot me a DM on Instagram and I'll answer this question for you. That's a great tease, though. Thanks for setting me up, Nicole. Jennifer, media has allowed us to ask questions. Example, Byron David Smith case. I cannot fathom why the judge didn't allow 2 years of theft/terrorism evidence by the victims who were shot breaking in. The media has held not only courts, but also law enforcement accountable certain times, in our history. So again, just cutting out the public is not what you want to see as a free country and as a citizen of a free country. That is absolutely a bad sign. But we also need to make sure we're doing the right thing with our responsibility, or with our responsibility. What is it? With great power comes great responsibility, something like that. We have a responsibility to do this appropriately and have this balanced. Thank you, Vivian. All right, let's get to Kohberger's motion to not have cameras in the courtroom. Again, I think following the precedent of Vallow and also confirmation that they are, in fact, watching us. So a sip here before we start. The issues. This court should limit the media coverage of this case to protect the Sixth Amendment. This court should not permit the media to use cameras to permit unfairly prejudicial coverage of Mr. Kohberger or to harass courtroom participants. And number 3, the court should not permit cameras in the courtroom to distract courtroom participants from the real purpose we are here. Facts. Mr. Kohberger's charge and subsequent courtroom proceeding have captured the attention of local and national news organizations as well as social media platforms. Agreed. The court has previously permitted cameras in the courtroom in regards to this case's prior proceedings. True. However, given the sensationalized nature of the case, the audio and visual coverage has become material for news outlets and social media accounts to espouse their unfounded opinions. Following each of Kohberger's court appearances, numerous social media posts have been made regarding him through Facebook posts, YouTube, guilty, and TikTok videos, and a podcast. Each video attempts to analyze Mr. Kohberger's demeanor by observing his body language from one court appearance and describing him as using phrases such as cold iciness. It looks like he is just filled with darkness and hate and keeps getting creepier among numerous other phrases. Not guilty of that. We do not do that here. And again, I think they are literally taking a page out of the Lori Vallow book, using what she looked like, whether or not she has makeup, that she's evil or whatever. And you can just tell from her body language and her persona. And those are the exact findings that the court used to get rid of cameras and get rid of microphones. So that should be concerning for those of us who do want public access to this case. But I wish people would be more appropriate in how they broke it down. And here's a lot of posts. Check out my appearance as I break down Bryan Kohberger on Law and Crime. If you've never seen evil before, this is what it looks like when you're in the presence of a demon. Nancy Grace breaks down disturbing new details released about Kohberger. It looks like he is just filled with darkness and hate, cold iciness. Again, he probably could have found 1,000 of these to post. While the media holds the critical role of informing the public of criminal proceedings, the right only exists to the extent that it does not impede on the rights of the defendant and is subject to maintaining fairness in the judicial process. A fundamental right of every defendant is a fair trial by an impartial jury established by the Sixth Amendment of the United States Constitution. In all criminal prosecutions, we know this already. We've read this. The court held in Shepard, given the pervasiveness of modern communication and the difficulty of effacing prejudicial publicity from the minds of the jurors, the trial court must take strong measures to ensure that the balance is never weighed against the accused. Thus, the court has a duty to preserve a defendant's right to a fair trial and must limit media exposure when it is apparent that the accused might otherwise be prejudiced or disadvantaged. To preserve a defendant's right, the court must balance the rights of the defendant and the First Amendment right to the media. We know that. The court should not permit media to use cameras. Here we go. When cameras are present in the courtroom, the defendant becomes subject to a minute scrutiny as his or her every movement can be replayed and analyzed. We said we did not like this as we were talking through Lori Vallow, and as we've discussed the hearings in Kohberger's case. This is not really what it's for. Him cracking a smile or looking over at his counsel or whatever it may be, being broken down every minute, and every inch and everything that he does and the way that he does it. And potentially that's why he stood silent instead of even saying the words not guilty, because that would have been broken down. That's problematic. We got that. In the present case, Kohberger's actions are heavily scrutinized by self-proclaimed, again, experts using audio-visual footage from courtroom proceedings to make assumptions regarding his body language and character, which actualizes prior courts' concerns regarding the presence of cameras in the courtroom. For instance, a YouTube video titled "Psychologist Breaks Down Bryan Kohberger's Arraignment Body Language" purports to dissect every gesture, every shift in posture, every flicker of emotion that crossed Kohberger's face during this tense courtroom scene while utilizing only one courtroom video. Like Vallow Daybell, there you go. By the way, I have not read all this. I saved it to read it with you. Like Vallow Daybell, the purpose of the footage is to scrutinize Mr. Kohberger's actions. In Vallow Daybell, the court determined that footage during hearings demonstrated an inordinate focus on the defendant. We knew this was coming. We said this was coming when the order came down in Vallow Daybell, and it's the same state. And we do not learn our lessons as YouTubers and media and people that talk about this. We've got to learn our lesson. Body language stuff is not admissible in the court of law. And when we try to convict him based on that body language, I think it is problematic. Now, body language experts saying this is indicative of somebody lying, I think is fair game. This is indicative of this or that, or, facial cues, touching your face or whatever it may be. It does not guarantee it. It is not what's used to convict. It is not beyond all reasonable doubt. But studies and research show this or that, I think is fair game. And the way that we present it, I think is important. That's what I think is important. The way that we present this thing, or these things, I should say. Here, the court need not determine the purpose of a video utilizing audiovisual recordings as the purpose of the commentator's purpose is explicitly clear. And such a video would not exist except for the presence of a camera in the courtroom. Furthermore, the video posted on May 23rd garnered 44,000 views in 2 days, further demonstrating the high level of interest in the case and the potential impact of pretrial publicity. Additionally, an article published by the New York Post relied on audiovisual recordings to analyze Mr. Kohberger's body language. The article states that by dissecting his most minute behaviors, from the use of his tongue to his controlled reactions and the tone of his voice, can paint a picture of his mindset. By doing so, the recordings are once again being utilized to scrutinize Mr. Kohberger as the expert reached an uncorroborated conclusion after viewing only one video. It's a problem. I do agree. I think that's a problem. And again, that is why, people had their reasons and thoughts about why he stood silent. And my best guess is he didn't want somebody breaking down his body language, his tone of voice, how quickly he answered, how slowly he answered that question and said not guilty. It's just my opinion and my guess. And that's tough. That's tough. I like how the behavior panel does it, Al-Kira said. I have seen some of their stuff, and I think some of it's, I can't speak, and this is the problem with YouTubers and not knowing people personally. I obviously can't speak to everything any channel has done, just like they can't speak to everything that I have done. But I absolutely think there's a place for behavior panel and body language experts. Absolutely. Absolutely. I think there is a place for it. But I think we just need to be careful with how we discuss any of this stuff as lawyers, as body language experts, as whatever it may be. Despite the apparent popularity of articles and videos claiming to explain body language, many such claims are not supported by scientific evidence, as previous articles not cited by the self-appointed body language expert in video concerning Mr. Kohberger's explains it. In fact, studies have repeatedly shown that body language cannot accurately be read like a book. And he's right about that. And that's one of the reasons it's not admissible in court. Vincent Denault, a postdoctoral fellow in psychology at McGill University, explains how there is no innate universal language of the body. And when self-appointed experts associate specific gestures or facial expressions with particular meanings, the statements fall under the umbrella of pseudoscience. I will say, a lot of stuff is pseudoscience before it's science. And a lot of stuff eventually does become admissible at trial. So it's not to say that it never will. This is just where we are right now. Moreover, Denault describes how even keen observers cannot infer a person's thoughts or intentions based on their non-verbal behavior alone. Although they say, however many percentage of communication is nonverbal. Their nonverbal behavior alone, due to the lack of scientific support, is not reliable. Thus, when articles and videos proclaim to reveal an individual's state of mind, they only contribute to the ecosystem of misinformation in which disparaging comments and dubious theories flourish. Here's the other thing I want to point out that's clear. Regardless of if you let cameras in the courtroom, regardless of if you let media have access or there's a gag order, stuff's going to happen. People are going to say wrong things. Jurors can potentially be poisoned, the jury pool. Let's be honest. Okay, that can still happen. I'm coming up on 6 o'clock, so I gotta burn through this, and then I'm going to answer your questions. Along with making claims about Mr. Kohberger based on body language, social media videos also utilized audio-visual footage from courtroom proceedings to make comments regarding his character. The videos use phrases such as cold iciness, and if you have never seen Evil before, we've read this. As the court in Nebraska Press Association noted, such characterizations may impact a jury's determination, as their ability to decide the case fairly is influenced by the tone and extent of publicity. As such, these phrases are used to characterize and make determinations about an individual based on limited footage with no regard for the presumption of innocence, which may impact a jury's opinion. Presumption of innocence is important and needs to be talked about in every video, in my opinion. But I will say, not having cameras, I don't think is going to stop this. I will say Lori Vallow's trial absolutely had less interest because there were no cameras there, but it did not have no interest. It still had big interest. People were very interested. We still talked about it on this channel. They were releasing the recordings. Nate Eaton was doing a great job of doing recaps. People were still interested. So the interest does not go away by taking away the cameras. So I think it's disingenuous to make that argument that we can just have people go away if we get rid of cameras. No, I think more misinformation could come from that potentially. This court should not permit cameras. All right, once courtroom participants know they are being recorded, they may behave differently. The court in Estes held that when a case is steeped in pretrial publicity, televised jurors cannot help but feel the pressures of knowing that their friends and neighbors have eyes upon them. May be true, but I also think just being called, here's just another quick aside from real life, just being called on any jury, they know their friends are going to ask them about it and talk to them about it. And so could that affect their opinion and what they do in the case? And then number two, if they're called for this case, it's going to be long enough. It's going to be important enough that their friends and family are going to know, regardless of if the world is watching. Friends and family are still going to do that. And yeah, they could sequester a jury. We don't want to sequester a jury in every case, but they could. Oh, Leanne G. Thank you for this. 20 videos a day recommended for Vallow, more than Stock, which was televised. This is why you guys are so important to take part in the conversation. And I apologize that I haven't gotten to get to more of the questions because I'm limited on time for this video. I want to get through these documents. Televised jurors cannot help but feel the pressure, but also just jurors generally on a high-profile case feel pressure, whether or not there's cameras. The court further elaborated on how the presence of recording equipment may not be the distraction, but more so the awareness of being recorded. The court even goes so far as to say, not only will a juror's eyes be fixed on the camera, but also his mind will be preoccupied with the telecasting rather than the testimony. Following similar reasoning, the court in Vallow-Daybell, again, you have to invoke that. If they did what you want and you have precedent on your side, that's what lawyers do. It's what we're trained to do. It's also expressed concern regarding the additional pressure witnesses and counsel may be exposed to, knowing their every expression, utterance, and appearance will be captured and circulated without their control. The court also notes that the pressure placed on witnesses may unduly influence jurors as they make an incorrect determination regarding the witness, as they may make an incorrect determination regarding the witness while he or she is under additional pressure of being recorded. The presence of cameras also places additional responsibility on the trial judge. Judge not only has to preside over the proceedings, but also requires his utmost attention. We saw that in Gwyneth Paltrow's case and other cases where the camera's pointing, Stock's case, things like that. Additionally, the defendant may also be distracted by cameras. The inevitable close-ups of his gestures and expressions during the ordeal of his trial might well transgress his personal sensibilities, his dignity, and his ability to concentrate on the proceedings before him. Sometimes the difference between life and death dispassionately, freely, and without the distraction of wide public surveillance. If you think you've heard that before, you have. This is the same exact stuff they argued in Vallow-Daybell when the court, Judge Boyce, decided to get rid of cameras. As a result, a defendant may not be able to fully focus on the proceedings despite being entitled to having his or her day in court. Therefore, the presence of cameras allows for the potential that the courtroom will devolve from a place for the victim, society, and the accused to receive justice to a mere spectacle. And then the conclusion. Again, a lot of things can make a defendant uncomfortable and may affect his focus. That doesn't mean they have to get rid of it. It's all about balancing. Kathy, Yasu, remember, innocent until proven guilty. Everybody across all media platforms and social media platforms needs to remember this. Nicole, I agree with you. I've definitely seen this coming after the gag order and the Vallow trial. Thanks, Peter. I mean, unfortunately, we've all kind of seen where this is pointing, and I think we've kind of seen where Judge feels about this. Netwoman, without cameras, you will just have the reporters fill the gallery and still give their spin on reporting. I agree. And that's what the Johnny Depp lawyers and Murdoch lawyers, I think, were worried about. is just one person's interpretation as opposed to all of us watching it together. And then you get my interpretation, but based on other people talking, other experts, other lawyers, you can bring that in and bring that into the conversation and even your own experience because you can watch it together. We can watch it together. Thanks, YouTube, for choosing memberships. Linda Cooper, first, are they assuming the jury will like and base their verdict on media reports? I mean, I think it's fair to assume there could be pressure there, but it doesn't mean there will. I agree with you there. Second, if BK is innocent, it seems like he would want the public to see proof in court. Correct, but he's also right, and I know by representing innocent people, jurors sometimes just come in and they think you're guilty because you're sitting in that chair, and the media adding the pressure is not necessarily helpful to his innocence. Although I do tell you, Scott Peterson wants the cameras because he wants to prove his innocence, even though he doesn't have the burden to do so. Morgan, welcome. And PK, welcome. Mama Pink, I understand that the jury is not allowed to watch or read media about the case they're overseeing, but is a judge allowed to do so? Sorry, silly question. Not silly. Yes, they are. We saw it in Rittenhouse. We saw it in Johnny Depp. We've seen it references by judges in cases. They know what's going on in the media. They can't be pressured by it, and they're supposed to be kind of above that, which I think they're trained to do based on their experience. Jojo, to be honest, if he's innocent, I agree with him. Fair trial becomes difficult. I'm in the UK and following. In my opinion, fair trial would be tough. I appreciate this, Jojo. Cole Perry, the way you report on things has ruined me for other true crime channels. Not a bad thing. I simply can't bear the way some discuss the cases. What I would say is give them some grace and maybe see if you can have those conversations in the chat. If you get trashed for it, I apologize for that. But I think give them the chance to have some fair and balanced discussion about it. And if they don't want to hear it, then, it's your prerogative. It's your prerogative anyways, right? And I'm glad you're here. I'm glad you take part in our conversation. Even if there are going to be points that we disagree, I still don't want you to ever feel like that on this channel or anybody. Tori, can they just keep cameras out until they get their jury? That's absolutely a possibility. And Murdoch did a lot of that as well. Cameras were out unless it was open court. Mama of 3. What I don't understand is it doesn't matter what we see. It's just what the jury sees regarding exhibits and testimony because they aren't allowed to view social media during the trial. Right. But how do we know you, Mama of 3, are not going to be a juror and are now being poisoned? And you would have been a great and fair and impartial juror, but now you're ruined because you've watched all this media attention about it. That's the problem. And I hope it's okay that I used you as an example. I should have used Tori. We're ruining Tori as a potential juror with this. And that's what we don't want to happen, is to make that jury pool so small of people that just don't consume anything. Are you guys ready? Okay. Leah MT, I just hope BK gets a fair trial. Me too. I admit I don't have a lot of faith that it will happen. Maybe I'm too pessimistic. I'm kind of there too. I like to call myself a realist, not a pessimist. Somebody was saying in the meeting today, I'm just such a ray of sunshine as a joke. But I like to think of myself as a realist. Azam, hi, Peter. I remembered you received the gavel a year ago. Yes, your unbiased views is one of the reasons I'm sticking to your channel. Thank you, Azam. We love having you. Hope you never leave. Thanks for being you. You are going to be late to your dinner. I know. That's why I am signing off now. Thank you, Carrie, for this super sticker. And there will be more later. And stick around and turn on your redirect if you want to hear about the Scott Peterson trial. I love you all. Thank you so much for joining me. Sorry for the quick exit, but I've got to get to dinner. And there will be more. We will discuss this more as things happen. If you're part of the Rewatch crew, you're sticking around after I leave, post your questions in the comments. Follow me on Twitter and Instagram at Tragos Law so we can continue this conversation, and like the video on the way out. Whew. It's been a busy conference. Thank you. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter